Good evening, everyone. My name is Hussein Mahadi, and I'm our moderator for today's session on entertainment, business, and law on the Gypsy Mentorship and Internship Program. Good evening, everyone, and welcome to the call. I can see Mrs. Ofuamaro Gene on the call, our mentor. Good evening, ma, and thank you for joining us today.
Hi, good evening. Can you hear me?
Yes, I can hear you.
Yeah. Okay, and it's just Ufama, it's fine. Thanks.
Thank you very much for joining us. We are awaiting our mentees to join the call. I'm going to send a reminder on the group now. Let's just give me a few minutes before we start. Okay, so while we are awaiting our mentees to join the call, I'll be making a few announcements and also reading our mentors profile for today. Um, I'll start with telling us about the program. Gypsy Mentorship and Internship Program is a quarterly program for students and young professionals across Africa. Mentees are afforded the opportunity to access valuable advice, training, network, mentorship, internship, discussion forum, industry updates, and resource materials from experienced mentors. This program seeks to encourage continuous training, development, and evolution in Nigeria, Africa, and around the world. You can watch some of our videos on YouTube and LinkedIn and Facebook by searching for Gypsy or hashtag GypsyMIP. Some of the objectives of the program is to provide easy access, guidance, training, and resource material for students and young professionals in Africa, to facilitate dialogue and network among experienced and less experienced practitioners and stakeholders, to transform mentees into mentors and leaders for the next generation, and finally, to facilitate further mentorship, internship, scholarship, and job placement for the mentees. These are what Gypsy is all about and some of the objectives of the program. I'll be moving on to reading our first mentor profile for today, Ms. Ufoma Rogene Isiavwe. I hope I got that correctly. Sorry for the wrong pronunciation. She is an international professional with experience in multiple industries. Her legal background cuts across intellectual property, technology, compliance, and data protection. She is a beauty enthusiast with focus on the African beauty space. Her favorite hobby is trying out favorite foods from different countries. Thank you very much for joining us today. Um, I'll be reading the next mentor's profile, Miss Shukrat Amusa Modipeola. Amusa Shukrat is a seasoned intellectual property consultant, analyst, and educator. With a public sector experience, she holds a master's degree in intellectual property from the prestigious African University, Zimbabwe, in collaboration with WIPO and Japan government. Shukrat is the brain behind the Self brand, the intangible nuggets, which is responsible for fostering, among other things, intellectual property advocacy, awareness, and education. She is an absolute mentor at the Juliana Imam Intellectual Property and Creative Council, JIIPCC, and an alumni of the World Intellectual Property Organization with 15 WIPO certificates to her name. Shukra works hand in hand with the Nest Innovation Park and doubles as an IP focal person as well as a training facilitator. She is a member of the planning committee for the WIPO National IP Essay Competition, um, 2023, and also a member of the WIPO International Network for IP Education. If Ms. Sukrat is on the call, thank you very much for joining us. I'll be reading our last mentor's profile for today. Mr. Raphael Efe Irene is an entertainment, media, and intellectual property lawyer. He is the founder of TMT Africa, a platform that serves as its resource center and reference point for all matters concerning technology, entertainment, media, telecommunications, intellectual property, and fashion in Africa. He was formerly an associate in the entertainment, leisure, and medical law business units at Olaniwu Ajayi LP, a multinational corporate and commercial law firm headquartered in Lagos, Nigeria. He was also an intellectual property and technology associate at AELEX Partners, where he was seconded as a legal associate to Crunch Technologies Development Limited, an international technological service company as also based in Lagos, Nigeria. He has advised a wide array of clients, including international and local clients, on intellectual property, technology, entertainment, and media matters. He's well versed in the realm of entertainment and media law. Thank you very much for joining us, Mr. Rafa. Those are three mentors for today. That's the announcements I also have to make. So I'll be giving the floor to, okay, I can see some of our mentors are on the call. Mr. Raphael, good evening, and thank you very much for joining us today. We are still expecting Miss Amosa. We already have our first mentor on the call. So I'll be giving the floor to Miss Ufomaro Gene to
Ufoma is fine. Ufoma is fine.
Okay, Ufoma. Okay. Yeah, thank you very much. So the floor is yours to give us an overview on the topic. As we all know, the topic for today is comedy, skits, and digital content creation. Um, the floor is yours, Ma, for 30 minutes. Thank you very much.
30 minutes? Is it 30 or 15? I prepped for 15.
Well. Would love to listen and learn a lot from you. So that's why I'm giving you an attention.
Well, that means I'll make it interactive. So how many people do we have on the call that the mentees? Let me start from there. How many do we have on the call right now?
We have 4 mentees on the call, including myself.
4. Okay, and could each of you just text in the chat what aspect of content creation or skits you do? Like, do you create content? Do you write? Could everyone just in the chat text what they do? Oh, you need me to put on my video, yes?
Yes.
Okay. Okay, can you see me?
Yes, we can see
Okay.
you.
Okay, so could everyone just let me know in the chat what they do for the mentees? And then I will just get right to it. Please, I need us to be interactive. Okay, I'll just give it a minute. Are you able to see the responses? How are you saying? Okay. Okay, I have one. My instruction wasn't clear. I want to know what you do. It's IP, and today's topic is comedy, skits, and digital content. So I want to know who's active, who's a content creator, if you film, if you organize production. Yeah. Okay, let me see. We have one. Okay. Memes, that's cool. Educational law. Oh, we have a poet. Oh, that's really good. Fantastic. All right, so I will jump right into it. My background in IP is legal services. So I have experience in copyright, trademark. I did a bit of patents, but honestly, I like copyright most out of all. So with comedy, skits, and digital content, I will cover it from the legal perspective mainly, and then a few business points. So the first thing you need to know with content, skits, and comedy in IP, you can break it down into the script, the underlying material, or the theme of your skit, then the performance of that script, then the recording of the performance. And with the recording, if you incorporate music, soundtracks, and if your music has lyrics, those are individual IP pieces that have separate laws that regulate them. So that's audio content. And then we have images. So with this is you could have pictures of people. Like if anyone knows Aproko Doctor, his skits on Instagram and Twitter where he's talking about something and then he incorporates the video memes where you can see the people making the expressions, so things like that. And your images would be of people, places, and things, original artwork, and then logos of trademarked properties. So with these pieces I've mentioned, there's legal IP regulations that manage how the rights over each of these are administered. So with the script, you have the author of the script, the person that writes it. With the script, the author can sell, the author can license, or the author can be commissioned to produce it. The performance, this is the entire, well, performance is straightforward. This is the acting out of whatever the underlying material was. Then with the recording of the performance, that's where the script has come to life. You have it's put down in video and audio format, and then it's published to the platforms. Now, what I would like to address with the questions I received, we can talk about using consent in using original images into your skits and your digital content. Now, for that one, the first thing you need to understand is in the Nigerian context, we have the Nigerian Copyright Act, we have the Trademarks Act, we have the Patents Act, right? Each of those bodies of law regulates how IP is used and how it's protected when somebody uses it without consent. Now, in your skits, and let me let me pick one that's really popular. Someone like Lai Wasabi. In the skit, you have the theme that's running, you have the recording of the theme, and you have the music that's put in. Each aspect of that content has IP rights, and under Nigerian law, there's different regulations for how it is used and what can or cannot be done with it. Now, incorporating other people's work into your content, you would need to get permission if it's not in a public space, or if your use of it is not captured under fair use. Now, what that means is if Lai wants to use Davido's song for the background music, he would need to get permission from the right holders of Davido's music. Because Davido is big, one. Two, because it's Davido's work or whoever owns it, and it's not Lai's original content, he would need to make sure that as he's using it, he has a license or he has consent. If with a license, you can pay, or if it's free, it's documented that, oh, you're allowed to use it, you're allowed to use this much of the song into your video. Now, for another thing to consider is the platforms these digital content gets uploaded to for your skits, right? So things like Instagram, TikTok, Facebook, YouTube, Twitter, Snapchat, they have their own policies around what you can or cannot do with other people's copyrighted work and with your own, right? So bringing it back to the question on law that precludes skit makers from using images without the consent of the individual in the name of original content, I would center on copyright law. And I would also, copyright law and also platform policies, right? When you subscribe to a platform and you use their service, you agree to the terms and conditions. In agreeing to the terms and conditions of that platform, you have agreed that you're not going to do anything that violates the IP rights of other people that use the platform. Good. And then with copyright, you need to also know that it's territorial. So copyright laws in Nigeria and how the Nigerian system handles infringement or unauthorized use or fair use is different from what you'd have in Ghana, is different from what you'd have in the US, is different from what you'd have in the UK. Now, the concept of fair use, so I'm getting ahead of myself. So it's, you are allowed to use content without consent in specific situations. One of it is educational purposes. Another would be satire. So like what a good example is what Josh Tufani does with popular music, where we know he's making a joke about it, which borders on what most skit makers and comedy content creators do. Now, there's also limitations to that fair use, right? If you take the entirety of the work and you just replicate it, right? In that circumstance, it's very unlikely that you'd be able to get away with fair use. Then also you need to check that where you're posting your content to, you need to have at the back of your mind that you need to check what their own stipulations for fair use is. Because there are instances where you post things online and then the platform takes it down because you're using somebody else's original content, usually a really big artist. Okay, the other thing with consent on original content, if you use people's images, music, photographs or whatever in a manner that's set up to defame or slander them, there is a restriction on that use of the original content. So in that aspect, you can't say it's educational, you can't say it's satire. There's a thin line between what's funny and when you're actually defaming somebody's character or when you're putting out false information about people. All right, now moving on to implications of using third-party copyrighted material in skits or performances, and how content creators can go around to get licenses for such material. I've already touched on it. The implication, you can be sued depending on who, where it's happening and what the right holder decides to do. If you sign up to a platform, they can take you down, they can ban your account, there's strike downs. YouTube has this thing where if you infringe on someone's copyright and they take it up, they can demonetize your channel or your account. And yeah, so that's the main part. With permission, your easiest bet is to get a license, or you could get a waiver, or you could figure out how to keep your use of the content within the definitions of fair use under Nigerian copyright law. If you're posting it internationally, you need to go through, or you can get your lawyer friends who know what they're doing to help you go through the terms and conditions to make sure that the format of the content you're uploading, it satisfies whatever terms the platforms have agreed to. And the best thing, you can send a DM, you can, for really big or established creators, they tend to have legal teams, so they have a business team that helps them process the request to use it. And a better option is to create your own original content, or to collaborate with creators that are upcoming like yourself, where you guys work together and create things together and agree amongst yourselves that, okay, we can use it and keep it moving. Now, does anyone have any questions so far? I cannot hear you if you can hear me. I think you're muted.
All right. Thank you very much, Ma. We've had more mentees on the call. I think you can ask the first question you asked again for those that were not here. And anyone that has any question, you can just unmute yourself and ask a question.
So my first question before we field questions is for the mentees on the call. What do you do with digital content and skit making, or what kind of content do you create? You can just type it in the chat.
Okay, I have a question to ask.
Yeah, sure.
Okay, thank you very much. I just want to ask about the limitations that we have for comedy skit makers, just like the recent case that occurred in Nigeria about a guy called Trinity. So I believe if he was aware of maybe there's a particular limitation, even though that's or the offense that they charge him with is something, a law quite known. But are there limitations? And is there a law that specifies for that limitation, maybe in the Copyright Act or any other law?
Okay, thank you for that question. The first thing is, could you give me context on who Trinity is and what he did?
Okay, Trinity guy is actually a comedian. He's a skit maker also in Nigeria, in Ibadan.
Okay.
So
okay.
He actually, how will I say, there was the charges on him was assault on a minor. So So there was a minor that in the skit, the minor was actually describing a manhood, gender, and something like that in the skit.
Oh, okay. Okay. So that would not be under copyright per se. That's more of a civil or criminal law issue. For if it's assault, that would be litigation. That would not come under infringement of copyright in any form. It would be more of a thing of decency. And yes, thank you, tort. It'll be a tort, and it would be civil law. If there's criminal elements, it'll be for the criminal courts to prosecute. But for that one, you're looking more of towards civil litigation, criminal litigation, what the criminal code is based in Ibadan. So you need to get the procedures for Ibadan. For copyright, in that instance, it would be more of most likely indecent or immoral content. And with that, platform regulators generally have stipulations on what you can and cannot do. And if you're going to post like mature adult content, there's what's it called? There's requirements for you to do that. But in this case, like I said, what you've described is more of a tort criminal civil offense as opposed to a copyright infringement offense. Your other question on the laws, for copyright issues, you have the Copyright Act, or IP, you have the Copyright Act, you have the Trademark Act, you have the Patents and Designs Act. Then you also have civil procedure rules for how to prosecute. And as of now, it's the Federal High Court that has jurisdiction over IP infringement matters. I hope I answered your question. But if you're not clear on anything, let me know.
Yeah, I understand now, ma. Thank you, ma.
All right, and any other questions?
All right. While we're waiting for other questions, thank you very much once again, Ms. Ufoma. I'll be giving the floor to our second mentor. I believe we still have this question and answer session. Here we'll take the questions that were sent and also ask for live questions. So
okay,
we'll still get to that. Yes, ma'am. So,
all right, thank you.
I'll be calling on Mr. Raphael to kindly unmute himself and give us an extensive overview of the topic for today.
Hello, good evening, everyone.
Good evening, sir.
Can you all hear me?
Yes, sir. Loud and clear.
Okay, so today's topic focuses on. Sorry, I can't start my video. I'm having network issues. I fear that if I put on my video, you may not be able to hear me clearly. So my sincere apologies. So today's topic focuses on comedy skits and digital content. Like I always say, whenever I have the chance of discussing this topic, for decades, we had two major subsets of the entertainment industry. We had the music and we had the movie subset. But in recent times, particularly given technological advancement and evolution, we've seen the development of the new subsets, which is the comedy and particularly the digital content subset. So with respect to comedy, skits, and digital content, as much as these subsets of the entertainment industry are relatively new, that is comedy, skits, and digital content, there are laws that particularly govern them. And one of those laws revolves around the laws governing intellectual property. When it comes to comedy skits and digital content, I think the primary focus would be copyright and trademark. So I'll take copyright and trademark particularly because a comedian puts out content, a skit maker puts out content, a digital content creator puts out content, just as the name implies. So it is imperative, this is for the mentees now, if you are dealing with a content creator or if you're a content creator yourself, if you're a comedian, it's imperative that you understand what the laws governing, what the relevant copyright laws states with respect to this industry, because it is very, very, the provisions of the relevant copyright laws are very, very imperative. You know, under the Nigerian Copyright Act 2022, for example, we have works that are eligible for copyright protection. We have audio-visual works, which I believe comedy, content creation, and skit making particularly fall under. We also have a bit of sound recording and musical work for content creators that put out their content like music or through audio mix. Although there is a difference between sound recording and musical work. I would have loved to explain that, but if I go into that, we may not live here today. We will dive into areas such as publishing and all. So with respect to, I'll say let's just limit this conversation to audio visual works. Now, before audio visual works, what we had was cinematography under the old dispensation, copyright dispensation in Nigeria, or copyright regime in Nigeria. But given that cinematography, the scope of cinematography is a bit limited, we now have audio visual works, which expands or stretches the applicability of copyright protection for video content to include basically almost all forms of video content, all forms of and skits, comedies, like as far as it is expressed in a video format or in a video form, and it meets the requirement for copyright protection under the Nigerian Copyright Act 2022, then it is protected, or it is protectable, in quotes, by the Copyright Act. Then with respect to trademark, I would say trademark is imperative, particularly because as a comedian, as a content creator, or as a skit maker, you are a brand yourself. It is beyond the comedy you put out. You are a brand. Like if you mention Sabinus now, if you mention Brother Shaggy, if you mention Tauma, if you mention Basket Mouth, if you mention Gandoki, if you mention I Go Die, I Go Save, like these names ring, they all ring a bell, respectively. So it is imperative that you trademark your name. It is imperative that you register your name or your brand as a trademark. And beyond your name, comedians, skit makers, and content creators also have certain, I would not call them, okay, they can be called slangs or slogans, or they have certain things that particularly identify them beyond their name. Something Uj, for example, Sabinus is one of such things, one of such words or items that identifies the brand of a comedian. So those things are also trademarkable too. So I would say, like I said earlier on, trademark and copyright, they are the most imperative forms or types of intellectual property rights that accrue to that applies to that industry, the content creation, the skit making, and the comedy industry. Now, beyond intellectual property, I would also like to mention, because I had someone ask a question with respect to the content creator that did a video, that put out a content where he was playing a very funny prank on a child. Now, beyond intellectual property, now you have to understand this. I think it is imperative I start this way. Can you all hear me?
Yes, sir. We can hear you loud and clear.
Yeah, beyond intellectual property, as I was saying, there are other laws that govern comedy, skit making, and content creation. Now, we do not have a standalone law for these areas. Like there are no laws there's no comedy act, there is no skit making act, there is no content creation act. No, we don't even have laws like as per state level. But then there are other laws in other areas, or other laws that govern other issues that applies to these areas. Now, for example, that's the issue of that content creator that was pranking that child. I think while the Cyber Crimes Prohibition and Prevention Act does not particularly make provision on that issue, it makes provisions that are quite similar to such an issue. Now, if you are a content creator, you have to understand that the Cyber Crimes Prohibition and Prevention Act governs your activities to the extent that it regulates the activities of persons. In fact, people that operate online, people that operate using computer systems or using the internet. The Cyber Crimes Act regulates their activities. So, for example, the Cyber Crimes Act, by virtue of section, I think section 23 or 24, I'm not particularly sure now, prohibits child pornography. Like any content that looks like or that resembles child pornography is highly prohibited. So I don't know if you can remember a skit by two upcoming skit makers that ended up ending their own career with their own hands. A skit where they used a little child, a little girl. Apparently, the skit was such that the little girl had a big butt, like a big bum now, in quotes. And the landlord, which was the second skit maker, was looking at the little girl, was lusting after the little girl. So people saw the skits and they came after those guys, crying out that the skit was bad. It reeks of child pornography. Apart from that, you're not supposed to be treating a minor in such using such sexually sensitive expression for a minor. So at the end of the day, I think the Nigerian police intervened. Those guys took the video down, but I don't know how their career has been since then. But I know those guys can actually be an action, or I would say they can be charged under the Cyber Crimes Prevention and Prohibition Act, because that passes for a criminal offense, and that act is a criminal law. Is an act that governs, that its scope and applicability revolves around criminal law. You understand? Then we also have ACON regulations. That's the Advertising Regulatory Council of Nigeria. Now, the reason why I'm mentioning ACON is because most content creators, skit makers, and comedians, they are fond of taking up adverts on behalf of brands and companies and organizations. Now, I know at some point, ACON was requesting, that is ARCON, ACON was requesting that some of these adverts should be registered with them so that they will be able to vet the adverts to ensure that they are in line with the relevant advertising standards in Nigeria. So that, for example, is also there. Then we also have data protection. Now you have to ensure that if your skits or your content references a data subject, you have to ensure that the license of that, the approval or consent of that data subject has been obtained. You understand? So I think we also have, even up to the FCCPA, the Federal Competition and Consumer Protection Act, because they are also, your content, for example, is a product, is a service. So if you are being paid to provide a service and you are not providing it in line with the standard that is required, if it is not fit for purpose, I believe the FCCPC they can come in and you can be liable under the FCCPA. So this industry is broad. It's a very big one. There are no standalone laws, but the legal regime for this industry is quite broad. Beyond copyright, beyond trademark, beyond intellectual property in general, you just have to understand that there are other laws, there are other areas that govern the content creation industry, the skit making industry, and the comedy industry, even up to defamation too. So if your comedy defames a person, defames a brand, except you have the defense of justification, I don't think you will not be liable if that person you defame, directly or indirectly, decides to bring an action against you. Then back to copyright, back to intellectual property. And the first speaker, Ufoma, talked about, she referenced fair use, she referenced instant issues or areas that could possibly serve as exception for copyright infringement, for example. So I would just say generally, in conclusion, I would just say generally, as a content creator or as a skit maker, you have to look out for copyrights. You have to look out for trademark. Is your brand or your name trademarked? Your content is entitled to copyright protection. Of course, there are exceptions. And you also have to make sure that that content you are putting on. So this is where I will stop my overview. Thank you very much.
Thank you very much, Mr. Raphael, for that very educative overview and introduction to the topic. I believe our mentees got 1, 2, 3, or 4 things from that. So I'll be giving, before we call on our mentees to give their presentation for today, I would encourage everyone to turn on their videos and smile for the camera for at least 30 seconds. I'll be taking screenshots of the session today. We do this to get some screenshots from the session so that we'll post about the session on our social media platforms. Thank you very much as you do so. Yeah, thank you. Oh, it's getting dark. Yeah, we all are. Thank you very much, Abu Huraira. Daniel, Amina, Otitotinu, okay, Otitoni, Jesu. Okay, wow, I didn't check earlier. Thank you very much, Alo. Okay, I've taken few screenshots. While Mr. Raphael was talking, I think Miss Amosa joined us. I didn't check. So welcome to the call, Miss Amosa Shukrat Modupeola. Our topic for today is content skits and comedy creation. So I'll be giving the floor to you to also give us your inputs on the topic before we take our mentee's presentation.
Hi, Hussein. Good evening. Can you hear me?
Yes, we can hear you. Good evening.
Okay. Hello, everyone. I joined quite late. Actually, I thought the program was for tomorrow, if not because Amina entered me some minutes ago. So I actually listened to Mr. Raphael's presentation, and I think he actually did a good job because when it comes to entertainment generally, especially content, skits, it's not just IP. Like IP is not a standalone law on its own because you have to relate it with something. It's either you're relating it with business, or you're relating it with entertainment, or you're relating it with tech. It just has to go along with something you are relating it with. So IP is not standing alone. It can't stand alone on itself. So with regards to skits, digital content, which IP now will fall in that character? So Mr. Raphael has mentioned copyright. Yes, copyright falls in that character because it protects the content. And we should remember that copyright protects literary and artistic work that has been expressed and fixed in a medium. So I want us to take note of expressed, fixed, take note of original, expressed, and fixed. So before you can actually claim copyright, your work has to be original. So it's not as if you go and copy Brashagi's skits and just do the same thing he has done. That's in that way, there's no originality. Because even while watching, I can tell that this skit was copied from Brashagi. There's no originality. You are not putting anything that makes it original to you. So your skit has to be original. Now, when it is original, it has to be fixed in a medium. You have to put it somewhere. It could be on social media. It could be on flash drive. It just have to be somewhere. It's somewhere whereby you can easily duplicate it. So that way you have copyright protection over it. Now, it doesn't hence them. Because when it comes to copyright is quite complicated. And copyright gives every copyright holder two broad rights. One is the economic right and one is the moral right. So for example, you will notice that there are some people that really don't call out people when they use their skits. That's because they actually don't focus on the economic right. They are more interested in the moral right. So I usually ask people, before you can say that you want to go into anything that has to do with IP, you have to ask yourself, why am I doing this? Am I doing it for economic sake, or am I doing it just to put it out there? Because if you are doing it to get economic benefits, then you have to be able to like put in the appropriate protection measure. Because most of IP require registration. Even copyright doesn't require a registration, but it is advisable for you to deposit your work with NCC. That way you are able to prove infringement one way or the other. So if you've created a work and maybe your motive behind that work is just to put it out there and get your name known, not necessarily because you want to make money from that right, a person like that might not call out people who are infringing or who might have infringed on their work. So that is why we have intellectual property theory. So each theory serves their own purpose. Are you looking at the utilitarian theory? Is it the natural right theory? Is it the incentive theory? So it depends on what you are doing. When it comes to copyright, the economic right is that right that you can economize, like you can make money from it. So under that economic right, we have about 6 other rights under the economic right. I also believe Mr. Raphael mentioned something about that. Then under the moral right gives you only the right of attribution. For example, when somebody else uses your work, you have the right for them to attribute that work to you. And they don't have the right to distort the work without your permission. That is where your moral right comes in. Now, how can you use somebody's work without infringing? That's another aspect we need to look into. So when Joshua Funny started his comedy and skits, you realize that somehow he's going to like take somebody's song or take somebody's music or movie and kind of put it in a way that is very funny. Things like that, we call it parody. But you can see that from what he is doing, he's actually using somebody's material. However, he has added his own originality to what he is doing. So do we call that copyright infringement? That is the case. How can you defend? Yes, like infringement is infringement, but there are some cases you can defend that infringement and say, okay, fine. Under copyright, if you use somebody's work without permission, yes, it's called infringement. However, there are some exceptions. And one of those exceptions is fair use or fair dealing, which parody now falls under. So you have to look at how you are using that work. Are you using it for educational purpose? Are you using it for news reporting? As long as you are not commercializing it, the moment you start to commercialize the copyrighted material, it becomes an infringement. Now, back to Just So Funny. Can we all say that Just So Funny has not commercialized one of those copyrighted work that he actually transformed from somebody else? One way or the other, we can say yes, he's making money online and he probably might have commercialized it. But is there any proof of commercialization? Can we show that he's actually commercialized it? So most times when somebody actually work on another work and kind of transform that work into a new work entirely, we call it transformation or transformative views. So transformative views does not require you to seek permission from the original owner. If you have transformed a work from one copyrighted work to another, you don't need to seek permission. But if you are adapting that work, adapting the work means the original work is still going to be there. That underlying original work is still going to be. So with respect to adaptation work, you have to seek permission. So you need to know the kind of work or the kind of angle you are going as a skit maker. Or I can't what's this other guy name? There was this Ashake music. I think is Black Bones, if I'm not making mistake. He made one parody of Asake's music, kind of. People were like, it's copyright infringement, it's not copyright infringement. So you need to understand how IP works, the limitations, the exception, especially with copyright, because copyright is more like the main back body for entertainment, skits, anything that has to do with artistic or literary video making is basically on copyright. Then with respect to trademark, there was a time Mr. Macaroni called out Wema Bank. Mr. Macaroni called out Wema Bank for trademark infringements. So Wema Bank sent a message to their customers saying, "Oin, you are doing well." And when you look at that phrase, "Oin, you are doing well," everybody knows that that's something that is meant for Mr. Macaroni, right? But the question is, was it trademarked? So the first mistake Mr. Macaroni did was he didn't trademark the word "Oin, you are doing well." However, when you don't trademark a word, but that work is already known by people that this word is for you, you can lie under passing off. So passing off is always referred to, is mostly used with unregistered trademark. A trademark that you do not register, but over the time, that trademark or that mark has gained popularity and people can identify that trademark with you. So because when people saw the message, people were like, "Oh, did Mr. Macaroni give Wema Bank the right to use it?" It's also happened with Jumia and I think it was RMD. They used his image to promote one of their content, and that's where image rights falls in. So when it comes to image rights, privacy rights, these rights are not really captured in our Copyright Act, and it's not really under copyright. But we have to understand that there's image rights, there's privacy rights. You can't just go ahead to use somebody's picture without permission. And I can remember the last debate IP Institute had. It was, should content creators, should participants, like people in the video, should they give them money? Let's say, for example, you have shooting video as a content person, and you now have people that are just passing by. Those passerbys, should you give them money because maybe they added one or two elements to your video to make it interesting? And people were like, so what if that same video now gave that passerby fame and the passerby become a celebrity? Is that passerby also going to give the owner of the video money? So it's a discussion that people we need to have, and we need to understand as well. During the Asake, help me, they carry me, they go where I don't know. People were like, Asake was supposed to like give the lady that was saying, help me, give her money. But the thing with copyright is, like I said, originality and fixation. It was not the lady that fixed that work herself. It was the person that recorded her saying that, help me, they carry me, they go, I don't know. That's the owner of the copyright. However, let's assume the lady was now featured in Asake video saying that, then she can now sue him for image rights or right to privacy because she didn't ask him to put her in a video. So all of these things are things we need to like consider whenever you're putting content out there. Even me, as an IP person, I made a video about Idabasi. Not really about Idabasi, but it was when Idabasi was doing the Cookathon challenge. So I wanted to relate intellectual property with cooking or with the restaurant industry kind of. So normally I really don't like to use people's image for my content because I'm trying to escape copyright liability, even when I know that it is for education's sake and education falls under fair use. I try as much as possible not to use people's images. So a lady came to my DM and was like, why didn't I use Idabasi's picture? Because I used like a white person picture, which I picked from Canva. That my page, my content was kind of misappropriating, or what was that English she said? Was confusing, kind of. And I was like, number one, the content wasn't to promote Idabasi. And in the first page of the content, I explained why I'm doing it. I said it, okay, this post was inspired by Idabasi, blah, 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 blah. So I want to relate how IP applies to the food industry. Do you understand? So all of these things, you have to explain it and let people know. So people don't assume I'm trying to use Indabasi's fame to grow my content. Do you get? Although it was for educational purpose, and that falls under fair use. But even at that, I didn't decide to use Indabasi's picture. So we have to be very careful when it comes to copyright IP, so we don't get carried away by what we are doing. And before you know it, somebody is sending you infringement notice and cease and desist letter. So I'm going to stop there. Thank you.
Thank you very much, Miss Shukurat Amosa, Mr. Raphael, and our first mentor, Miss Ukwoma. I'll be taking our mentee's presentation now before we jump into the question and answer section. Our presenter for today, please, if you're on the call, you can share your screen and start your presentation. Thank you very much.
Can you see my screen?
Yes, you can see your screen.
Like, can you see the slide?
Yes, we can see your slide.
Okay, thank you very much. Thank you very much. Thanks all our mentors. I presented a presentation today, which is based on comedy skit and digital content creation. I believe most of what we have here in our presentation has well been reiterated from our mentors. But however, to show we following them will make more analysis from our presentation. So just like we know that comedy tends to be one of the dread of acts, definitely deals mainly on laughter, is actually deals with human and wit and other stuffs also. Skits is actually something that is short and it is actually sketchy. So you could deliver comedy by making a skit. Like comedy is there, you're not making a skit of comedy. It tends to be short. Now, the digital creation of it is the aspect of using digital technology to create it, but not only comedy and other forms of videos, animations, music, and other form of content. Initially, just like Mr. Raphael mentioned for us, that back in the days, technology, when it has not advanced to this stage, then they are unable to be able to use the internet, just like now that we are able to share our comedy skits through online, and you are able to make it through your phones and other things. So the digitalization of the comedy has actually opened a new opportunity for a lot of content creators globally in the world. So we have the likes of examples that we know, Mr. Shaggy, Lasisi Elenu, Taoma, and stuff like that. Mr. Shaggy started with the main content like the Agbero Life, in which he sticks to it. And he is known for that, just like our mentor just mentioned earlier, that is known for that particular thing. Now, the business and structure that has to do with more comedy aspects, yeah. Structuring your for someone that wants to be a content creator, structuring definitely has to start from the social media. You have to have a social media account, either the TikTok, Instagram, Twitter, and among others that we have also. Definitely that is the first step. Why the second step tends to do with being to get creative. Now, this creativity here that we are talking about is definitely, if you want to create a skit, you have to have what actually works for you, what people will recognize you with. Like the aspect of the Mr. Macaroni, him being a sugar daddy, is what people know him with. So like that, like Taoma, people know Taoma acting the skit of a mother and a daughter. So people know her for that. Also, the third step is to be consistent consistency is very, very important in skit making and other things, because definitely people are making videos with time. They are making videos day in, day out. And the more views they have, the more the engagement on their content. Also, we know that in the days, most comedians, let's say comedians, we have most stand-up comedians, that these stand-up comedians, they are not into comedy skit making. And these comedians that we know before, they are not into all this deep branding. But now, as we know, Nigerian comedians are in millions of endorsements from different firms like Coca-Cola, MTN, and other things like that. This is part of the business aspect of it. Also, in the aspect of comedians that we know, for instance, Ayomayoku now is actually into movie too. Upon that, he's doing comedy. He's known for that, like The Merry Men and Basket Mouth and the likes of them, like that. So we know that definitely under the business and structure that deals with comedy, we know that skills engaged by comedy skit creators, definitely they must have creativity. The storytelling deals with the script of what they want to do, of their own unique story that the world will know them with, the video production, editing, branding, marketing, and all sorts. Also, the legal aspect of it, which has been well reiterated by our mentors also, talking about the copyright, the content IP claims, music and sound effects, that some people, there are some comedy that we know that, okay, like the likes of Bayu, when he's ending his own movie, comedy skits, we know what he mostly ends with, like fuck shit. So things like that, music and sound effects, that are common, that we know, okay, this is the one this one used to use most of the time. Trademark, privacy and data protection, defamation and libel. I believe all these has been well reiterated by our mentors also. So the IPRS, which is the intellectual property rights, mostly revolves around the copyright, in which is the copyright protection grants exclusive rights to the creators of original work, including scripts, sketches, and comedic performance. They have the right to reproduce, distribute, perform, and display their work. Now, these copyrights serve as a shield for them, in which still we know that in some situation it's been infringed. Definitely is being guided by the Copyright Act of 2022. Now, in Nigeria, we know that the copyright lasts for 70 years, 70 years after the death of the initiator of that particular work. Nigeria, like that. We have some other countries also, like Albania, also is 70 years. But Nigeria, that is close to us, is like 50 years after death. So we have like that. But still, we have a commission, Nigerian Copyright Commission, that actually help in regulating this also by you registering with them to be known in order to serve as an evidence in courts when somebody is suing someone that infringe his or her work. So under intellectual property rights, definitely we have the copyrights, the fair use, licensing, trademark, digital rights management, patent, software, and the likes. Now, definitely it is known for every general rule, there's always an exception. So exception to this, just like has been well reiterated also by Mr. Shukrat, that made us to understand also, and Mr. Rafael too mentioned it, and our first mentor also, that the exception to this is the fair use, which actually she mentioned about the parody. So the fair use actually, if it is being used in some exceptional manner for like education, commentary, criticism, and news reports also, is actually being permissible as far as it is not being commercialized. So definitely this skit making that they're having also, definitely they are getting their money from it. And the means that some of the means that they are using to get their money, that is income streaming and realities, are sponsored advertisements that occurs when you're watching your comedy, then this so-called advert will just come in. So the merchandising also that deals with the marketing also, the affiliating marketing, that when they market a particular product, per person buying that product, there's actually a gain also for them. The subscription that you do from your phone with the social media, like that. So these are part of the ways that they do actually make money through these kits and others like that. Under infringement and enforcement, definitely we should know that the problem that comedians they face, the problem of joke theft, is often ignored and seen as an unspoken code of conduct among comedians. Just like our mentors has mentioned earlier, that there are situations, a lot of situations that are being faced by these people when they want to enforce their rights of digital creators about what they have done. Is not that easy for them whenever there's an infringement. So part of the method for them enforcing it also is sending a cease and desist letter. A cease and desist letter is a letter telling that body or that particular person that they should desist. They should take that thing, that work that they have done by them infringing on their copyright, that they should take it down. Also, we are filing a lawsuit. That one is going to court. Also, using a DMCA takedown notice. A DMCA takedown notice tends to be a digital Millennium Copyright Act. Also, because it works, is an automated takedown process whereby automatically it works automatically, but there's a lot of explanation to it, whereby some pay, but some is done personally, some is being done by professionals. So there's a payment for it, that when so form of infringement or somebody copies his or this person's work, this thing is being automatically done to take it down. And international laws to also guide it. I believe with this little that I've explained now, we have actually been able to pinpoint little things about the comedy skit and digital creation that revolve around the intellectual properties right and the copyright. I think this is our humble submission. Are you with me?
Yes, we are with you, our presenter. Thank you very much for that very wonderful presentation on behalf of the whole group. Thank you very much, all the group members that contributed, and also the group leader for making sure that the work is ready on time. I'll be giving the floor to Mr. Raphael and Ms. Shukurat to give any contribution they have on our mentee's presentation or any correction on the research done. I'll call on Mr. Raf to go first.
Sorry, I didn't get that. Come again.
Okay, sir. I said I'm giving you the floor to give any inputs, like contribution on the presentation or any correction.
Okay, so I actually read the presentation earlier today. So I would say that the presentation was actually well prepared. But I think references, there are instances where references were made to the Nigerian copyright law, I think it would be better next time if you just reference the Nigerian Copyright Act 2022. You understand, other than saying the Nigerian copyright law.
No.
Then I think the presentation, the topic and the presentation are a bit far apart. So if you observe, when I came on board, I took my time to go beyond intellectual property. I went as far as talking about cyber crimes, talking about data protection, consumer protection, and all. So the topic says comedy skits and digital content creation. This is very wide. This is very open. If I hear a topic like this, my assumption would be that it is beyond intellectual property. Now I understand that the this whole mentorship program particularly revolves around IP and entertainment. But I also believe that it is imperative that next time you touch on other issues. You understand? And by so doing, you may even fall back to IP. Because I know that to an extent, IP and data protection can be a bit related. IP and image rights can be a bit, and rights to privacy rather. IP and the right to privacy rights and all can be a bit related. So it is also imperative that you touch on these other areas sometimes when making a presentation like this, or you just indicate from the get-go that the presentation is limited to IP and you con your topic around that area. In terms of substance, yes. In terms of structure, I'd also say yes, that the structure was good. I mean, it touched on copyright, fair use and fair dealing, licensing, trademarks, digital rights management, patent software, trade secrets and all. I am not particularly setting out trade secrets would relate, as it's particularly with respect to content creation. But I know copyright is there, fair use and fair dealing, as an exception to copyright, is also there. Licensing is very imperative. I mean, when skits makers or content creators make use of songs, when they sync, the process is called synchronization. When a content creator is making use of a song or is making use of mostly a song actually in their content, or in his or her content rather, that process is called synchronization. You are syncing the song with your content. Licensing comes to play on that ground. So, you know, there are two types of licenses. We have exclusive and non-exclusive. For non-exclusive licensing under the Copyright Act, non-exclusive licensing can be made in an oral form, and it can be made to more than one person. But exclusive must be written down. You understand? It must be in a written form when you are making an exclusive license. So just take note of that. Without licensing or without consent per se, they are closely related in this sense. If a content creator or a comedian or a skit maker is using the song of an artist or using another content, it amounts to synchronization. And if it is done illegally, you'll be liable for copyright infringement. And trademarks is also there. Digital rights management is also very imperative. So, and I know we have a question and answer session. I will talk more about this DROM when we get there. Then patent and software, innovation. So I know patent particularly regulates or governs innovation. I would have said this may not apply, but it does apply actually. Now, it does not apply from the content creator standpoint, except the content creator has developed an application through which he puts out his or her content. Like today now, we all know today the guy that interviews controversial personalities, high-profile personality, controversial personality, today has a website through which people subscribe to the website to access his videos, his interviews. So in that sense, I think patent and the laws governing patents would apply. So that is one area. I think next time you can expatiate on things like this, on issues like this. Then trade secrets. Well. I said this does not particularly apply initially, but I would say to an extent it does apply, because I remember there was this DM that an upcoming content creator, an upcoming skit maker put out. It was a DM of his chat with Sabinus, where he was requesting that Sabinus feature on his skit with him, that they do a skit together. So Sabinus told him to put up an idea, an idea of the skit basically, and send to him. So in that sense, if you are going to produce a skit, you would have to ensure that the whole production is a bit I will not call it a secret now. Just has to ensure that third party do not get, people that are not directly involved, do not get to hear of such production, so they don't steal the idea, they don't steal the concept of the skits. But you also have to understand that in Nigeria, there are no laws particularly governing trade secrets. So when we make use of is NDAs and non-disclosure agreements. So next time, if you mention trade secrets, you should simply put NDAs in bracket, because I think the only law that I would say is close to governing trade secrets in Nigeria is the TRIPS agreement. Unfortunately, TRIPS has not been domesticated in Nigeria. So as it stands, we cannot particularly mention trade secrets. So you just, either you substitute with NDA, a non-disclosure agreement, or you just reference, you mention trade secrets / NDA. Then you go further to explain that, okay, trade secrets does not have a legal regime in Nigeria, but the alternative is to make use of a non-disclosure agreement in that sense. So I think this is it. You guys did well. And personally, I had a lot to learn from the presentation. So well done. Thank you.
Thank you very much, Mr. Raphael, for that input. All our mentees, I believe we've taken down corrections, and we'll do better in our next presentation. I'll be giving the floor to Ms. Amosa if she has any contributions before I start taking the questions.
I really do not have any contribution. I think Mr. Raphael has finished everything I have to say, because seriously, IP is not the only thing that revolves around entertainment law or skit making and digital content. But the thing is, even when you finish talking about everything you want to see, you still have to come back to IP, right? So don't just limit it to IP. It goes beyond IP. It goes beyond IP. You have to like get the right formation for your business, contract agreement, your tax and everything. So it's not just IP. It's just that when it comes to monetization or somebody using your work without your permission, all of this has to be put in place. But it doesn't just revolve around IP. Like I said, IP is not standalone. IP cannot stand alone. We have to like put it in something. So what are we putting IP in? If you don't have the content, for example, if you have not created any content, IP cannot even come in, because like the 5 circles of IP, you have to create first. So when you've not even created it, IP cannot come in. So in the process of creation, what do you have to do? In the process of creation, let's say I come to you, Uzi, and I say, okay, I have an idea for a comedy and I want to share that idea with you. I've not created it, it's still in my head. I'm trying to like tell you what to do. But before then, probably you and I must have signed a non-disclosure agreement. That's where trade secrets comes in. So you must find a way to like put in everything together. No, don't just revolve it around IP, like your image rights, your privacy rights. As a content creator, you have to like have all of those things at the back of your mind. Defamation and all of that. So it covers more than IP. So Mr. Raphael has done a good job. Thank you.
All right, thank you very much to both mentors for the contributions and the corrections. So we start taking the question now. The first question is for you, Ms. Amusa. Question number 1 says, is there a law that precludes skit makers from using image without the consent of the individual in the name of original content?
Is there a law that precludes from using images without the consent? No, you can't use images without consent. So are you saying, now when you say images, is it the video or the image now? Because this takes us back to copyright. Copyright protects original work of authorship fixed in a medium. And we say the creator or the author of an original work owns the copyright. So let's say, for example, now you want to shoot a video, and you probably told a videographer to come and shoot the video for you. Please remember that the copyright to that video is for the videographer, not for you. So if you post that video, the videographer can come and tell you that, hey, you are infringing on my copyright, except if there was an agreement between you and the videographer, whereby the videographer transfers copyright ownership to you. So you have to be careful uploading your photographer or your videographer's image, even if it is the image of you, as long as you are not the one that clicked the shutter, the person that clicks the shutter owns the copyright. So always make sure there's a transfer of ownership agreement. Without any transfer of ownership agreement, then you can't use it. Now, the new Copyright Act says something about privacy and private use. Before, the right to ownership belongs totally to the photographer or the videographer. But now, the purpose of that content now comes into play. So if I want to use the video that I asked you to video of me, I want to use it for a personal use. It's not as if I want to go and use it to make money. I also have the rights. I have a non-exclusive right. When Mr. Marshall was talking about licensing, he talked about exclusive licensing and non-exclusive licensing. So that Copyright Act is giving me, the person, a non-exclusive right to use that work, but not in a commercializable manner. I can't commercialize it. I can't make money from it. I only have the right to maybe post it on my Instagram because it is just for personal use. But if I want to make money from it, then I need to like notify the videographer. Maybe whatever, we have an agreement, whatever it is I'm making from that video, there's a particular royalty that will be going back to the person that took the video took the video or took the image. So you can't expressly use somebody's rights without permission. The Copyright Act does not give you that permission to do that. The right belongs to the photographer or the videographer, the author or the creator, except there's an agreement that transfers ownership to you. Without that agreement, it belongs to the photographer or the videographer. I hope I was able to answer the question.
Yes, thank you very much, Ms. Amosa, for that answer. But I want to ask, what if you paid the videographer? There's no agreement, but you paid the videographer for their work.
Yes, payment doesn't give you ownership. The fact that you paid doesn't mean you own it. See, no, that's the mistake we make. Some people are like, now, but do you know how much I paid him? You paid him for his services. Okay, now let me ask you the question. If we go to a bookshop to buy a bookshop, don't we pay? Does that mean you wrote the book? Did you write the book? You didn't write the book. The person that wrote the book is only giving you a non-exclusive license. No, that one is, yes, a non-exclusive license to read the book, because the non-exclusive license gives many people license to read the book. But it doesn't mean you own it. So the fact that the photographer snapped your picture and you gave him money is money for service, not for money. It's not money for ownership. So we have to be very clear that payment does not guarantee ownership, except there is a contract that is transferring the ownership to you.
I think we need to revisit the law.
Somebody is asking, no, the photographer also cannot use your image to make money. It needs your permission. So this is where it comes. If the photographer comes and say, okay, fine, this is your image, I want to use it. Then you and the photographer can now decide to say, okay, you use my image for promotion of this person's video. How much will you give me? Give me royalty, blah, blah, blah. So it's vice versa. The photographer cannot use it. Even you can't use it. But if the photograph was taken in a public space, let's say you are a celebrity, you are just going around and photographer camera you and use your image, you can't blame the photographer because you are in a public space, not in a private space. The photographer did not come to your room to snap you. You can't be in a public space and still claim right to privacy. Mama don't want to. Do you understand? You can't be in a public place and claim right to privacy.
No, thank you very much, Ms. Amusa. I think that is a very extensive answer to that question. I'll be taking the next question for our second mentor, Mr. Raf. How can digital content creators use digital rights management effectively to protect their work? Are there any potential drawbacks or challenges associated with implementing digital rights management?
Okay, so when that question was shared with me, I felt it was a bit dicey because, but then I'll give an answer to the best of my ability. First, What is digital rights management? It is the use of technology to control and manage the access to copyrighted materials or work in general. So for those that do not understand, when you know the world is evolving, like I said earlier on, and as a result of that evolution, we are seeing certain innovations every time. Now, you know, there are some websites that when you access the websites, you cannot download something or an item from the website. You can also not copy from the website. There are some websites that you cannot even copy certain things, copy any write-up. So those are products of digital rights management. They ensure what digital rights management does is that it limits the ability of certain persons or users to an item, particularly a copyrighted item. It also limits the ability to share, to illegally synchronize, illegally download certain copyrightable work or copyrighted works rather. Now, for content creators and skit makers, the reason why I said it's a bit dicey is because, some content creators actually want to be seen and they want to be heard. Some of them also want, on the flip side, as antithetical as this sounds, some of them also want their copyright to be heavily protected. Now, there appears to be a very blur line, a line that is a bit unclear between protecting your copyright and being heavily seen. So you want to restrict your content to ensure that people do not have access to your content so that they don't infringe on your copyright in that content. I mean, are you not indirectly restricting your people's ability to in fact, restricting or reducing your own popularity, particularly where you're an upcoming content creator? So I think what digital rights management is about does not particularly favor content creators in general. But I would say that yes, it can be used, particularly where you are an established content creator or a skit maker. You can, like today, for example, that I gave an example with, he has a special website. On his website, you cannot download his interviews. I think it favors, this whole system favors established content creators in general, you understand? Except if you are a content creator and you want to restrict access to your content, which I believe would also affect you. It would affect your like the level of attention that you would get. But then I think it is also a good way of reducing copyright infringement. Also a good way of reducing data breach, and also a good way of fighting cyber crimes, ensuring and guaranteeing cyber security. Now, what are the drawbacks? Like I rightly mentioned, it will affect your popularity as a content creator, comedian, or skit maker. Because if people do not have access to your content in general, the popularity will drop or it will not increase. On the other hand, it's also very expensive. It's a bit expensive to implement. Like putting up a website, having a special channel for your work, and putting up restrictions. It's just like a content creator making his IG page private. Of course, if you make your IG page private, if you make your IG or your Twitter page private, people will not have access to bad actors, people that infringe on copyright will not have access to your content rather. But then it will affect your popularity in the long run. You understand? So I think this is the major drawback, the fact that it affects you, affects your brand, one. Number two, it is also expensive to implement. And three, it doesn't even particularly fully guarantee copyright or intellectual property protection. You understand? So I think while it is good, these are also some drawbacks. It does not guarantee copyright protection to the extent that if you put your page on private, for example, now, people that are already following you, one way or the other, they can see if they want to. We have this feature, this screen grabbing or screen recording feature. Someone can still screen record your video, despite the fact that you have limitations to how people can use or download your content. You understand? So it is not a full protection or immunity mechanism. You understand? So people can still breach your copyright, your IP rights, if you use digital rights management. But then generally it is good. So that's it.
All right, thank you very much, Mr. Raphael, for extensively explaining that question. I'll be taking the next question for Ms. Amosa Shukrat. What are the implications of using third-party copyrighted materials such as music or images in skits and comedy performance? How can content creators obtain proper permissions or license for such materials?
Well, the implication of using third-party material without permission is the fact that your content is likely to be taken down and charged for copyright infringement. So let's say, for instance, imagine you have a very good number of subscribers on YouTube. Then unfortunately, you kind of added a third-party copyrighted material to your video. That can eventually lead to taking down your YouTube page. And you know what that is going to cost you? It's not going to take down only the material. They can eventually take down your page eventually. So that's going to cost you more. Because you have to, even all your original videos, you might have even lost that one too. So it's not about copywriting. Even when you infringe, if you have an original work and you are infringing on somebody else's work, you see that work, it has copyright protection, but you won't go scot-free because you are infringing on somebody else's work. So if you put somebody else's work in your own original work, that work has copyright protection, but you also have to clear the fact that you've infringed on somebody else's work. So the best thing to avoid infringement is, number one, look at the work you are trying to use. Not even infringe. Look at the work you're trying to use. Is it a copyrighted material? Or is it a copyrightable? Is it something that has copyright protection? Let's say, for example, there are some works that you cannot protect. If it's an invention, copyright doesn't apply to invention. Or let's say maybe there is this flag of Nigeria that belongs to the government. Things like that. The flag itself now, not the image of the flag. The flag itself as an element cannot be copyrighted by somebody else. You cannot say you own, you can't create or say you can't say you own it because it's for Nigeria. So things like that, I'll take you back to the recent case between a photographer and Wakana. So the photographer took a particular image of some people doing a cultural blah, 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 I think in Anambra. So Wakana decided to use that image to promote their business. What they now did is they took out his trademark. The trademark on the name, they used something to block that trademark, so the trademark wasn't showing. Then they used the image. The guy now charged them, or he demanded for money. They now said that they are not going to pay him because the image is claiming to have copyright over is not a copyrightable material, because they believe, or because we know that the Copyright Act says that emblem, insignias, and all of that belongs to a government cannot be copyrighted. However, the photographer actually took a picture of that roundabout, and it has elements of people dancing around it. The fact that the photographer has put in his own original element to edit that video and do everything gives him copyright over that work. So before you can say that you want to use a third-party work without infringement, you have to make sure that the work is not a work that is copyrighted, or is not an element. It's not something that you can copyright. For example, if you use somebody's brand name, brand name is not copyright, it's trademark. So you have to make sure that it's not something that has copyright protection. Number two, if it has copyright protection, what is the purpose of your use? Does your use fall under fair use? If your use fall under fair use, you can kind of find a way to, dodge that copyright infringement and defend yourself by saying, okay, fine, you used the work, but it was under fair use. And fair use doesn't see usage of that kind of material as infringement. So those are some reasons where you can actually use somebody's work. Another reason is if the work has expired and is now in the public domain. Like presenters, when the presenter was presenting, he said copyright lasts throughout the lifetime of the author and 70 years after the death of the author in Nigeria. So Mickey Mouse, the Mickey Mouse character is now in the public domain. So everybody can use it. Is it Mickey Mouse? I think yes, I think it's Mickey Mouse. So before you can use work like that and want to not infringe on somebody's rights, you have to make sure that number one, is not a copyrighted work or is not a work that can be copyrighted, number one. Number two, you want to make sure that if you are using that kind of work, you are using it under fair use and not commercializing the work. Number three, you want to make sure that the copyright protection has elapsed and the work is now in the public domain. So in those three occasions, you might be able to avoid infringement. And the other part of the question says, how can creators obtain proper permission? The best way to obtain permission is to reach out to the person. Reach out to the person you want to use their content. And this is where CMOs come in. Because most times our artists, they are now big and they can't reply to everybody's response. So most times they kind of give CMOs, collective management organization, they give them their rights to license on their behalf. So if, for example, a DJ wants to go and play in a club, the DJ is meant to go to collecting rights organizations to collect permission, license, to be able to play those music he wants to play in that clubhouse or in that party. But first of, the artist or the musician must have registered their work with the CMOs. Then the CMOs will give license to the DJ that want to use it. That's because the artist or the musician cannot respond to everybody's message. But if you feel like it's somebody that you can get in touch with one-on-one, just make sure you seek permission before you can use that kind of name or content or image or skit. So I'm going to stop there.
Thank you very much, Ms. Amusa, for that answer to the question. Before I take the last question, for those who are mentees still on the call, if you have any live question you want to ask, you can just type it on the chat box or raise your hand. So I'll call on you to ask your question before we end the session today. Okay, I can see a new question. Is it just monetary gain that defines commercial purpose, and social media popularity be deemed to be commercial usage if the usage is to the end that you get more IG followers, which can then bring you influencer GIGs? I don't really understand, but Mr. Mose, I think you can relate to that question on the chat box.
Sorry, what's the question? I think I missed the question.
Is on the chat box right now. The person just sent it now.
Is it just monetary gains that defines commercial purpose? Can social media popularly be deemed? Yes, it's basically monetary gain, because most times, and I think that's one of the issues with the what's this guy's name? Pressure Tiwa. Which billboard uses work again? So a billboard uses work, but now we cannot prove that they received any commercial value from it. Although we know that one way or the other, they might get money from it. But was it for commercial purpose? Did we see them get money from it? That's one of the things, because if maybe you printed or you put somebody else's work in Dix, you know that one way or the other, that Dix will sell and they'll get money. But can we actually access your Instagram account to know if Instagram is paying you for a particular skit or not? So most times monetary gain is what we call commercial benefits. Or maybe sometimes we can say, because of you use this particular work, this person work gave you exposure. And that exposure brought in deals for you. You can also equate that to monetary commercialization, because of that exposure, more brand get to partner with you because you used somebody's copyrighted material. So if you had not used that copyrighted material, you probably might not get the exposure that you had. So most of these photographers, when they want to sue celebrity, they will tell you, yes, I took a picture for you, and you used the picture you posted the picture, and this brand reached out to you, this and that. So that picture or that copyright material has given you the influence, the exposure to be able to make some other commercial gains. So I'm going to put it that way.
Okay, thank you very much, Mr. Musa, for that clarity. I'll be taking the last question from Mr. Raphael, question number 4. In the context of digital content distribution platforms like YouTube or streaming service, what are the specific copyright policies and guidelines that content creators should be aware of? Do we still have Mr. Raphael on the call?
Please come again.
Okay. The question is, in the context of digital content distribution platform like YouTube, copyright policies and guide of.
Your voice was breaking. Sorry, I don't know if it's my network or yours.
Maybe it's mine. Let me take it again. In the context of digital content distribution platforms like YouTube or streaming services, what are the specific copyright policies and guidelines that content creators should be aware of?
Okay, so I think each platform, social media platform or DSP, beyond Instagram, Twitter, Facebook, and the rest, we also have platforms like Spotify, Apple Music, that through which content creators put out their content, like podcasters, for example. Now they put out their content through Spotify. Now, specific copyright policies that should be looked out for, I think it's just to go through their respective or their individual terms of service or terms and conditions. So I know Instagram, when you join, because I did something related to that. I've done something related to that twice. I've advised an artist with respect to the release of his song, where the guy used the viral TikTok sound. So I had to examine TikTok's terms of service. So I know when you join TikTok, when you upload a video on TikTok, you automatically give TikTok the right to authorize other users to use that content. So it is such that if Shukurat, for example, is a content creator and she uploads a video on TikTok, she has copyright in that video, but she's also licensing TikTok, granting TikTok the rights to authorize other users to use that video, to use the video itself, to use the sound or any other elements accompanying the video. So you have to observe the terms and conditions, specifically the copyright provisions, the intellectual property provisions in general, just to be sure that first, your right is protected. Secondly, it is not a platform that once you upload your content like this, other persons automatically will be entitled to download and use that content without your own approval. So Instagram is very strict. Instagram, if you upload the content on Instagram, another person does not have the right to use that content. In fact, Instagram will flag it. I know there was a time I uploaded a video of Tupac, of one of Tupac's songs, or one of Tupac's videos rather. Keep Your Head Up, that talked about respecting women, talked about shunning rape and violence against women and all. So I uploaded the video sometime in 2020 when and a rape-related issue was on. So I was just using it to encourage men to be better persons, to be good people. So to my greatest surprise, Instagram flagged it and stated that the copyright in the video belongs to Universal Music. So apparently, Universal Music is now overseeing some of Tupac's copyrights, Tupac's catalog rather. And as a result, they have copyright in the said catalog. So I think you have to be watchful, you have to be mindful of things like that. There was also an issue related to StockX the other time. StockX is a platform through which people buy sneakers. So although that was an issue, it wasn't a copyright issue, it was an issue related to whether a minor can sue. So things like that, as a content creator, always take out time. Or if you can't, get a lawyer to do that on your behalf. Take out time to read the terms and conditions of the social media platform that you are joining before you upload your videos, before you upload your content. It is not late if you have already started uploading. I know there are some content creators that started as far back as 10 years ago, 5 years ago, 7 years ago. It's still not late. You can still review and know how to upload your content. Like I've mentioned now, Instagram, if you upload another person's content or if you use another person's song in your skit, Instagram will flag it. I've received complaints from content creators and influencers several times asking me for, they come with their complaints and ask me for advice on the way forward. So I always tell them that this is an Instagram policy. You understand? So I think that's it basically. Thank you.
Thank you very much, Mr. Raphael. Thank you very much, Ms. Shukrad. We lost our first mentor. She left the call by 7. So many thanks to all our mentors for coming here today and sharing a lot with us, the mentees. It's very impactful and educative. Thank you very much for our mentees too that did the PowerPoint presentation, the whole team, and those that stayed with us to the end of the call. With this, we've come to the end of today's session on entertainment, business, and law. For our mentees, if you have any further questions, you can send on the group chat and we'll forward them to our mentors to send you the answers. And also do well to follow our mentors on their social media handles on Instagram and LinkedIn. You would get a lot of educative contents from their page, especially Miss Shukrat Amosa. Her name on LinkedIn and Instagram is DIN, the Intangible Nuggets. She has a lot of content and recent updates. Thank you very much, everyone, and have a lovely night. Bye-bye.